Hello friends, कैसे हैं आप लोग? So today we are going to start with our Article 20. In our last lecture we completed Article 19, which was a big article divided into three lectures. So kindly look at that also. Today we are going to look at Article 20. So let's start with that. So this Article 20 is quite important as far as our exams are concerned, and it is also necessary to have a basic understanding of it in order to get the gist of our constitution. So, so far, like we discussed with equality principles, Article 14, 15, 16, 17, 18, then freedom principles of Article 19. But this article is quite different. This is a bit specific. What it does, it also falls in the category of freedom rights, freedom principles, but it is a bit specific to criminal law. So students who are interested in understanding criminal law or are doing something in IPC or CRPC or other criminal acts, they should focus on this article to get the holistic view of it, because this is the basis. This is the basis. This is the basic law, which is the first thing that you need to have a grasp of. Okay, so let's begin with it. Again, Article 20 is quite big. It has three sub-articles. So I will be dividing this video into two parts. Let's see. Okay, so this is our lecture 13 and Article 20. Article 20 sub-article 1 says no person shall be convicted of any offense except for the violation of a law in force at the time of the commission of the act, charged as an offense, nor be subjected to a penalty greater than that which might have been inflicted under the law in force at the time of the commission of the offense. See, there are two parts of this very important sub-article. Okay, so the term which is commonly used to denote this sub-article is ex post facto laws. What is meant by this term? Okay, ex post facto laws means those laws which have been brought into force after the commission of the act. So, what is the impact of those laws which have been brought into force after the commission of the act? That is what this Article 20 deals about. So, Article 20 has two parts. The sub part, okay, we need to focus on this underlined area. So, the first thing, very important thing that we need to understand is that Article 20, Article 20, which we are doing right now, is available to both citizens and non-citizens. Try to remember, Article 19, which we dealt yesterday, was available only to citizens, but this Article 20 is available to both citizens and non-citizens for the reason that the term person is used. And this term person may also include corporations, companies, and all. Okay, so no person shall be convicted of any offense, okay, except for violation of a law in force at the time of the commission of the act. Okay, which means the meaning of this first part is that no person shall be punished except for the law for violation of a law which was in force when that particular act was committed. Just say, for example, that a particular person commits a particular offense on 1st of April, okay, and a particular law is brought into force on 3rd of April, okay, into force. Okay, it has been enacted in our statute book and it comes into force on 3rd of April. So this person who committed that particular act, which is falling under the definition of offense under this law, which has been adopted on adopted on April 3rd, this person cannot be punished under that law for the reason that that person committed offense on 1st of April and the law has been brought into force on 3rd of April. So he can only be punished for those acts which were falling under the definition of offense on 1st of April. So the day, the time when the offense was committed is very crucial. If only if the acts which a particular person committed were falling under the category of offenses on that particular day when the offense was committed, he will be liable to be punished. This is the gist of this first part. Okay. Nor be subjected to a penalty greater than that which might have been inflicted under the law in force at the time of the commission of the offense. So, in the first example, in the first part, what was the case? That on the 1st of April, when the offense was committed, those acts which were done by that person were not falling under the definition of offense. And the law came on 3rd of April, which made those acts as a part of offense. So he was immune from that law because of ex post facto factor. In the second part of Article 20, Subarticle 1 says is, just suppose that person who is committing the offense on 1st of April and the acts he is doing, he is punishable for those acts for 5 years imprisonment. Okay, but a law has been brought into force on 3rd of April, which enhances that punishment to 8 years, just say. So, as the act was committed on 1st of April, and when the act was committed, the maximum punishment for that offense was 5 years. So this person A can be punished for 5 years only. So this enhancement of punishment, which has been made applicable for since 3rd of April, cannot be applied to this person who committed the offense on 1st of April. So these two parts. First part deals with when the act was committed, it was not an offense at all. But in the second part, it was an offense, but the punishment was less. And by future amendments, the punishment was enhanced. In the first case, the acts were not an offense at all, but by the adoption of law or an amendment, they were made an offense. So this is the only difference. Okay, this is our Article 20, Subarticle 1. Okay, so there are three things which can come out of Subarticle 1. The first part dealt with first time offenses. Okay, when the act was committed was not an offense. By the future law, it was made an offense. Second part dealt with enhancement. When the offense was committed, the punishment was less. When the amendment came, it was enhanced, so it will not be applicable. The third point is procedural changes. Just suppose when the offense was committed on 1st of April by that particular person A, there was a different procedure. Just for example, that district court had the jurisdiction to try that offense. But by an amendment which came into force on 3rd of April, the procedure was changed. Just say a special court was made, or some other changes in the procedural aspects was made to that law. So, does Article 20 also cover this situation? That if the does Article 20 imply that the procedure which was existing on 1st of April, that will be applicable only? So the essential question is, does Article 20 cover also prohibited the application of procedural changes also? So the answer is no. Article 20, Subarticle 1 does not cover procedural changes. As a result, this person who committed the offense on 1st of April, and if an amendment is brought and a procedure is changed on 3rd of April, this changed procedure can be applied in the case of this person A also, because retrospectivity of procedural changes is not prohibited by Article 21. But if we look other countries like United States, the this clause of retrospectivity is also made applicable to procedural changes also. So in the US, if there are procedural changes in future, that cannot be applied to people who committed offense before coming into changes. But in case of India, they can. Okay. So the first important case under sub-article 1 is Sony Devraj Bhai versus State of Gujarat. This is a case of 1991. This case dealt with the first point, first time offense. Okay, so what happened that a particular offense of dowry death was committed. Okay, like a murder of a woman was committed who was a wife of a particular person. Okay, when that act was committed, the act of murder was committed, there was no such thing as dowry death in our Indian penal code. Okay, there was no section 304B. Okay, so but when the trial was on, when the thing was going on, a amendment came into force, and through an amendment, Section 304B was introduced to our Indian Penal Code, which made dowry death a specific offense different from murder and provided certain presumptions in it. Okay, so what were the presumption that the offense occurs within 7 years of marriage or whatever? So all those presumptions were not there when the offense was committed under this case. But all these presumptions and Section 304B was adopted after the commission of that. So this the question arose whether Section 304B of IPC can be applied to this case. So the answer was no, because it will violate Article 21, because it says, because when the act was committed, though it was an offense, it may be punished for some other section of Indian Penal Code, just say for murder, okay, or for culpable homicide. But as there was no provision of dowry death or favorable provision for women presumptions and all at that time, these presumption cannot be made applicable to this case. Okay, because it will violate ex post facto factor. Second important case for sub-article 1 is Maru Ram versus Union of India. In this case, very interesting thing arose. So when we say that we cannot enhance the punishment also, this is the thing. The question arose, so okay, we are not enhancing the punishment. What about the law? What a future law which is setting a minimum punishment for an offense? Just suppose that an offense has been committed on 1st of April, and the maximum punishment for that offense has been provided for 5 years. But an amendment comes on 3rd of April, and that provides that if that particular offense is committed, it is necessary for the courts to grant punishment of at least 1 year imprisonment. So 1 year imprisonment has been made mandatory for that offense which is committed. Okay, so the question arises: does this amount to enhancement? Is it violating Article 20, sub Article 1? So this was the question in Marura. What happened in this case? Section 433A of CRPC was brought into the statute through an amendment. What it said that if a particular person has been sentenced to imprisonment for life, or if he was convicted to death penalty and his punishment was reduced to imprisonment for life, he will not be left out of jail in any case before 14 years. So if a particular person has been punished with imprisonment for life, it is necessary in every case that he should be in jail for at least 14 years. So this was a minimum thing. It was not the enhancement of punishment. So in Marura, the Supreme Court held that this minimum thing is not violated, it does not violate Article 20, and it is allowed in this case. So Section 433A of CRPC can be applied uh, to the people who committed offenses before coming into force of Section 433A of CRPC. So it was made retrospective. Okay, because it was not an enhancement, it only provided the minimum punishment that has to be given. Okay, next important case was Kedarnath versus State of West Bengal. This is a case of 1953. In this case also a very important issue arose. The issue arose that when we see Article 20, okay, so it says that punishment. Okay, so Does this term punishment under Article 20, Sub-Article 1, includes the case of fine also? Like, is it equally applicable to fine? Just for example, that if an offense has been committed by a particular person A on 1st of April, and punishment for that act is a fine of 500 rupees. Just imagine if an amendment comes on 3rd of April, and through that amendment, the imposition of fine, the amount of fine has been enhanced to 800 rupees for that offense. Does this enhancement of fine is also prohibited by Article 20? This was the question in Kedarnath case. The essential question was, does this concept of fine comes under the definition of punishment, the word punishment that has been used under Article 20, Sub-Article 1. So in this case, this was a case of Prevention of Corruption Act. Okay, so in this case, a fine was enhanced, and it was the people were trying to implement it. The state was trying to implement it retrospectively. What was the clause was that if you have been found in like in the possession of a particular amount of bribery, you have to pay that amount in fine. So this was the enhancement. This was the enhancement of thing, a new rule relating to fine, which was supposed to be applied to retrospectively. So in this case, the Supreme Court held yes, fine is also covered within the definition of punishment under Article 20, and if a fine is enhanced or a provision for fine is made in future, it cannot be applied retrospectively to the people who committed that those particular offenses prior to the enhancement of fines. Okay, so the next important case is Ratanlal versus State of Punjab. This is a case of 1965. Okay, very important question, interesting question. So when we see the Article 1, what it says, that a penalty, second part of it, it says a penalty greater than. Does it say a penalty lesser than? No. So what does it mean? So can there be a penalty lesser to the amount which was there? Just for example, that if a particular person A commits an offense on 1st of April, and the punishment for that particular offense is 5 years, and an amendment is made on 3rd of April, and the punishment for that particular has been reduced to 2 years now, does this provision of reduction of punishment can be applied retrospectively to that person A? Or if does it violate Article 20 if a state tries to apply it retrospectively? This was the question in this case. So, okay, so this was the background of it. So, in this case, Ratanlal case, what happened was a young boy of 16 years committed an offense of house trespass, and he also during that thing he also molested a young girl. So he was imprisonment was given to him for like 6 months, I guess. Then an act was adopted, Probation of Offenders Act 1958. Okay, after the commission of those act. So that particular boy was in jail at that time. So what this Probation of Offenders Act provided was that no person who is below the age of 18 years will be imprisoned. Okay, so that particular boy was in jail at that time. So he tried to take benefit of this probation of offenders. So what the Supreme Court held that he was allowed to take benefit of it because Article 20, Sub-Article 1 only prohibited enhancement of punishment, not reduction of it. Okay. I hope you are understanding all these cases. If you want, please write them down, or otherwise take screenshots. Okay. So the next case is uh, Transmission Corporation of Andhra Pradesh versus Prabhakar. This is a case of 2004. Okay. This is the question which we were earlier discussing, that about the procedure thing. So the question in this case was, does Article 20 also prohibits changes in the procedure, which if they are to be applied retrospectively? So in this case, what was happening, that in Indian Electricity Act was amended, and by an amendment, so it was provided that all the people who are violating this act will be there will be special tribunals for their trial. So there was a change in the procedure, and it was they were trying the state was trying to apply to all the persons who also to the persons who had committed the violation of this act prior to the coming into this amendment. So this was allowed by the state because procedure thing is not covered by Article 20 and they do not violate Article 20. Okay, so the next important case is Hathi Singh Manufacturing Company versus Union of India. This is a case of 1960. So in this case, what happened was Section 25 triple F subclause C of Industrial Dispute Act was adopted. Okay, so in this case, for and like particular like if a particular industry uh, if a owner of an industry closes that industry without permission, so a particular fines were imposed on them. Okay, and there were also provisions for imprisonments, I guess. So the question arose, and this amendment was tend to be applied to the people who had committed those offenses prior to coming into this amendment. So the question arose whether this section 25 triple F is uh, uh, does it like affect or violate Article 20, sub Article 1. So in this case, court made a clear distinction between criminal offenses and civil offenses, and the court held that the terminology of Article 20, by use of the word offenses and punishment, it has been made clear that Article 20 is only applicable to criminal law and it is not available to civil offenses. And as far as Industrial Dispute Act is concerned, it is a civil law, not a criminal law. Even if there are provisions for punishment in violation of, like if a particular person doesn't pay that particular amount of fine, he will be imprisoned. Even for that reason also, it is still a civil act. So it is not applicable to Industrial Dispute Act, and this was allowed to be applied retrospectively. Okay, so this is important. This was our subarticle 1 that we discussed all these cases. Okay, so this is now we will move forward to subarticle 2. What does subarticle 2 says? Subarticle 2 says that no person shall be prosecuted, mind the words, prosecuted and punished for the same offense more than once. Okay? Okay? No person shall be prosecuted and punished for the same offense more than once. It means that no person, okay, so if a particular person has committed a particular offense, he will not be punished for it more than once. Okay, so there are three requirements of it. The first requirement is that particular person has to be prosecuted for it. What is the meaning of prosecution? I will tell you that. And the second requirement is the term is and, okay, not or. Oh, so both are necessary. Prosecution and punishment both are necessary. The second requirement is that person who is being prosecuted has to be punished also. And the third and the most important requirement is it has to be for the same offense. Okay, offense, same offense, not the same acts. Okay, I will tell you the difference. The term used is same offense. Okay, so there are three requirements. There is prosecution, there is punishment, and both of these have happened with a particular person, he cannot be prosecuted against for the same offense. Okay, this is the gist of this subarticle 2, and this is commonly called a provision on double jeopardy. Okay, so I'll tell you the meaning of each and every word through these cases. The first important case under sub-article 2 is Maqbool Hussain versus State of Bombay. This is a case of 1953. In this case, what happened was, uh, like a particular person was coming from a foreign country carrying a large amount of gold, which he had not declared in the documents, which he was required to be done. So he was uh, he was arrested by custom officers, and like the whole thing went on. The whole their own trials under the act were conducted. Okay, so what happened in future, this he was being prosecuted after this whole procedure under sea customs act. A new trial was initiated against that particular person under Indian penal code. in a normal session court. So he took the objection that the whole trial has already happened under C Customs Act, and I am again being prosecuted for the same offense because of carrying of that code, and this is hit by Article 20, Sub-Article 2, the law of double jeopardy. So the question arose: what is the what he said that I was prosecuted for it and I paid fine, so I was punished for it. Okay, so the provisions of Article Sub-Article 2 are satisfied. So the question arose, what is the meaning of this prosecution? Okay, so the court, like what will be understood by it. So in this case, the Supreme Court held that the 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 trial that took place under the Sea Custom Act cannot fall under the definition of prosecution. Prosecution means formal accusation. Okay, when when a normal no when a formal prosecution takes place, a normal judge comes forward. Okay, so there is this judicial authority which takes into consideration all the facts and makes a decision. Only then it will be considered prosecution, as the officials of sea customs authority were not judicial officers, so it cannot be held to be prosecution. It was more of a administrative inquiry or something of that sort, either administrative or quasi-judicial. Not the It did not have the judicial color in it, so it was not a formal prosecution. And now, as you are being prosecuted under Indian Penal Code, so this is your first prosecution for that offense. Okay, so in this case, the term prosecution, as far as sub-article 2 is concerned, was greatly discussed and defined. Okay, so the next case is Kalavati versus State of Himachal Pradesh. This is, in this case, very interesting point occurred. Okay, see what happens when a particular case comes before a session court for the first time. Okay, they take cognizance of the offense. Everything happens: evidence, examination, cross-examination, then there is decision. So now, suppose that a particular party is not satisfied with the decision of the session court. It goes into appeal in high court. Okay, does this also, the question about this appeal, is it like, is it the second prosecution for the same offense? Isn't it? Like, what is high court going to do? It is going to go prosecute that particular person again, or if possible it may punish that particular person again. And what is the thing that is giving them the power? The same offense. There is no change of offense. The question arose whether these appeals under criminal law are also violating Article 20, sub-article 2. So in the case of Kalavati, what happened was Kalavati committed murder of her husband for whatever reasons. Okay, so she was prosecuted, but there was her confession also, but she was not uh, but for some reasons state went against the judgment of session court into the high court, and she challenged that appeal thing. This is like a new trial, so I'm being prosecuted for the same for same acts, and I will be punished again. So this is violating article sub article 2. So in this case, the Supreme Court clearly held that appeals are the continuation of the original prosecution, which was started with the trial court, with the session court. It is the continuance of the same prosecution. With the what what it essentially meant is that with the judgment of the session court, that original prosecution did not end with it. It is still continuing through the appeals. So up till all the remedies available to either of the parties have been taken and used, the original prosecution continues. So it can't be said that every appeal gives birth to a new prosecution. So in this case, appeals were held to be continuation of the original prosecution, so there was no prosecution and hence no question of violating sub-article 2 of Article 20. Another case was Brijnath versus State of Bhopal. This is a case of 1957. In this case, this is very interesting. Okay, in this case, what happened that a particular persons were prosecuted for prevention of corruption. But you see, there are certain sections of this act which requires that for prosecuting certain ministers or members of parliament or state assemblies, you have to take prior sections, prior sanction of authority, that particular authority. In this case, that prior section was not taken. Okay, and like proceedings were initiated. So in future, the court found that no, you have not followed the required procedure. So it was held to be, the whole thing was held to be nullity, and they were left independent. They were left free, all the offenders. So in future, after following all these formalities of prior sanction, the state again tried to prosecute them. So in now they took the plea that no, we were prosecuted earlier. We were There was a particular decision of the court, and I am now we are being prosecuted for the same offense again. So this is hit by Article 20. So in this case, the Supreme Court held that no, this is not the second prosecution. This is in fact the first prosecution. And in the first case, when you were left free for the reason that prior sanction was not taken, the whole process was held to be nullity. Okay, you were not left free after considering the merits of the case. The case was thrown out because it did not follow the required procedure. So the whole proceeding was held nullity. When it was held nullity, it had no importance, no value in the eyes of law. So it is into vacuum. So this thing, so this is your first trial, and it is not violating Article 20 sub Article 2. This was the case of Krishna. Okay, so the next important case was Leo Roy Frey versus Superintendent District Jail. This was a case of 1958. Okay, one very interesting question. Just suppose that a particular act which a particular person does may amount to two very different types of offenses. Okay, under different acts, for example. So what, like if that particular person is prosecuted and punished for one of those type of offenses, does it bar the authority to prosecute him for the other type of the offense also? Just for example, that a particular person A, okay, commits a particular offense, say that he brings gold into India without permission. Okay, so first he will be prosecuted. So first he has committed offense under C Customs Act. Okay, second, if on inquiry it comes to know that he was with that gold he was into some terrorism funding and all. So now the same act is also falling under IPC or terrorism act, TADA and all. So the same acts are amounting to offences under two different acts, two different offences. So does his prosecution under C Customs Act debar his prosecution under TADA, or vice versa? So this was the question in this case. In this case, the act that was committed by the offender was falling under both C Customs Act and IPC also. So in this case, the Supreme Court held that C, the term used under sub-article 2 is same offense, not the same act. Okay? It doesn't say that no person shall be prosecuted and punished for the same act more than once. It says more for the same offense more than once. So what it means that a same act may amount to more than one offenses, and if he is prosecuted for that one offense, does not debar the state to prosecute him for the other offense, because it will not be the same offense, it will be the other offense. Okay, maybe the person will be the same, he will be prosecuted again, punished again for the same act, but it will be a different offense. So article sub article 2 of Article 20 will not be violated. This was Leo Roy Frey case. Okay, so the next case was Preetham Singh versus State of Punjab. Okay, in this case, the only thing that was discussed, that is important for our thing is, in this case, the concept of estoppel and our law of double jeopardy was distinguished. Like, what are the differences? Okay, estoppel is like when you say something or when you accept something, you are stopped from denying it. This is the rule of estoppel. And what does double jeopardy says is that once you have been punished for one thing, you cannot be punished again for the same thing. This is the rule of double jeopardy. So in this case, the Supreme Court said that estoppel is limited to evidence provision. Like if you have accepted something, if you have said something in court of law or in a particular document, you cannot in future deny it. And as far as double jeopardy is concerned, it is limited to the particular offenses under criminal law. That you have been convicted for a particular offense, will not be convicted again. It will like just suppose that a state prosecuted a particular person and he was discharged. So it is not an estoppel for the state to go. It was not an estop. It will not amount to an estoppel for the state to go against that particular person and prosecute him again. This will be a double jeopardy because of Article 20. But just suppose that the state has said one thing in evidence during the evidence procedure in one case, he will be that state will be stopped from saying the other thing, opposite thing in future. So this is the estoppel, this is double jeopardy, they are different. So only if you want to understand the distinguish, like the difference, you should read this case, otherwise well and good. Okay, so now this is the final part, sub-article 3. This I will do in my next video. I am going to stop it now, and let's see you in my next video. Bye.